in how they can be structured and what they can do. Formulation of them. Commission's working on them, so the Western Interstate Energy Board, I think, developed, or there was a group out of the Western Governors Association that developed the Western Interstate Energy Compact, and the board was established after that. NGOs can look into developing and generating interest in compacts, and in fact, we've got our folks from the National Popular Vote Initiative. They're not a government organization, they're a private organization, and they're working on they've come up with this compact, in fact. And as someone already said, several states have already adopted it. Private citizens, industry groups. This was a big thing, particularly with energy in the West. You had utilities that were very interested in trying to take away authority from FERC and other organizations, national governmental entities, that they didn't want to be subject to restrictions by FERC and others. So the industry groups actually developed compacts to try to restrict what the federal government could do. In case of the Colorado River Compact, that was congressionally passed, as I said. And there were 7 states that were involved in it. So we'll use this kind of as an example. The interstate water compacts, we have what's called the New Mexico Interstate Stream Commission. The Stream Commission itself was created in 1935, which you'll note was after the creation of that Colorado River Compact. But as things were going along, there became more and more water compacts that existed in New Mexico. So this is by example. I want to show you compacts that exist right now. There are 7 water compacts that exist in New Mexico that stretch through various states. Our Interstate Stream Commission is the body that governs that and makes decisions with respect to that. We've got some discussion on the Colorado River Compact. Okay, so 1922. This talks about what it was supposed to do, what states are part of it. New Mexico, Utah, Arizona, Colorado, Wyoming. These things, and it's interesting, when we talked about the idea of contingent compacts, this one didn't have to be contingent necessarily because it was congressionally imposed. They said, you will be doing this. And interestingly enough, somewhere it says, Arizona didn't actually consider itself a member. Oh, there it says right here. Did not ratify the compact until 1944. But the President of the United States said, okay, Arizona, I don't care if you ratified it or not. You're subject to it. You're part of it. And that gives you another flavor, another facet of how these compacts can work. This was one passed by Congress. It originated at the federal level. This national popular vote thing is something that's more of a grounds up. It's originating at the state level. I'm looking at how to do this.
So you can create administrative rules within the compact, so the compact members can set up administrative rules for how they're going to function internally, separate from the compact?
And in fact, I don't think I have that in here. Let me see if I've got it in my notes. The Interstate Stream Commission does have its own set of rules that govern how it acts, what it does, and that's flavored by what other states are doing. So yes, it can have its own governing body. It can establish its own administrative procedures and processes. I'm specifically not using the term regulation.
Jim, quick question. Did I see, so the compacts have to be congressionally approved? Did I see that up front?
We're going to touch on that a little bit later because the Constitution says they have to be congressionally approved. But there have been compacts that have existed that did not have congressional approval, but were still determined by the U.S. Supreme Court as being valid compacts. But the idea is there's congressional approval of it. And in fact, if you go back to the Port Authority one, the Port Authority initially did not have congressional approval, shall we say, but the Port Authority needed to go out and get bonding, get money, get financing to actually do the work that they wanted to do to fulfill the obligations of the compact. And I don't know, it was their lawyers, I'm sure, who came up and said, look, you're not going to get any investors in this unless you get congressional approval on it. So they went ahead and got So there's some practical sides to doing this. But we'll talk about that a little bit more. Okay, methods of enactment then. Basically what we're looking at is legislative action. There are, in sort of limited capacities, governor administrative agencies can establish compacts. But it's really a legislative function that we're looking at. And we already talked about this contingent nature of these things. I just threw up some that, these are all contingent, and they have different ways of expressing their contingent nature. For instance, the NPVI process, the contingency. Good morning. Come on in and have a seat.
Yeah, go
Yeah.
ahead, there we go.
The way NPV has it, and I think we've talked about this, is once sufficient states have joined the compact to reach 270 electoral votes, then it becomes an active compact. And then the provisions of the compact apply. And then members of the compact have to award their electoral votes in accordance with the compact, which says their electoral votes get awarded to the winner of the national popular vote. So anyway, that contingent nature is something that's typical for these things. All right, going back to Senator Worth's question, and the constitutional aspect of this, two reasons why congressional consent is necessary. One of the key things in litigation associated with compacts is the compact intruding on federal authorities, on what the federal government can do. And safeguarding the interests of states that aren't members of the compact. So there's a reason to have this federal anointment, so to speak, of compacts, because it takes it to another level. You get congressional enforcement and other things associated with that. But, as I said, there's been litigation on this, and I don't remember the case. You guys probably know it off the top of your head, Greg or
I don't know the case off the top. Yeah.
there's a case out there that actually the compact was found to be legitimate without congressional approval, but the court, I don't know whether the court punted, I didn't read the case in detail or anything, but I think the court kind of punted and said, look, it's not intruding on any federal problems, it's not intruding on other states' authorities and rights, and so there's no reason why this can't be an effective compact, meaning the contract is valid and it's enforceable.
Jim, do you remember whether it was submitted and Congress declined to approve it, or whether it just wasn't submitted?
That I don't know.
Okay. It seems like that would be an important factor in whether the court would uphold it or not. The
Could-
difference between Congress declining to approve it versus whether the state never bothered to submit it.
Yeah, I'm not sure how much weight the United States Supreme Court is going to give congressional action or inaction on something. But I think
I
they're-
think
what
they
they're-
did it, in other words, they just decide they don't want to approve it. I'm just thinking of like the rules of civil procedure and congressional inaction, how the court did it.
Yeah.
I
I mean, and I don't know the analysis whether they say, well, Congress was being arbitrary and capricious when they decided not to ratify this or to give it a blessing. It's hard to know for sure, and I don't know on this one particular case.
I just think that'd be interesting.
What's
But
the
the
distinction
legal,
you're making then? What's the
Well,
distinction, what are you thinking about
I
there?
think that the court would be more deferential to Congress if Congress declined, as opposed to if the states had never submitted it. But I haven't read the case, so I'm not sure, and I'm kind of not sure which case you're talking about, so I'm gonna read it.
yeah, I'll get you the site.
Okay.
I can get that for you. And greatest respect for you and all, but I'm not sure that they're going to. What I think they're going to look at is the long history, the legal history of compacts, and say, and look at the tests, the elements that they're looking for, and whether or not the compact as a contract should be enforceable or not. And does it intrude on federal powers and authorities? Does it intrude on other states? I think that's going to be their analysis. But
Yeah,
because you
I'm not
really
sure.
want to rely on Congress to make that analysis.
Jim, a
Sorry.
question that you sort of seem to be having a presupposition here that I want to ask about. Is it the intent then of the National Popular Vote Compact not to seek congressional approval?
That, I'm gonna leave that for Kim and Lana.
I don't know the answer to that. I think that they should.
Okay, I'm just
To give you
curious.
if I may, to give you the general general thought, we agree with your analysis regarding infringement on state authority. We believe we do not, on federal authority, we believe we do not. However, when we get to 270, we probably will go to Congress to get their approval, just to kind of like icing on the cake.
But isn't that
Why?
an important thing for states to know when they enter into that compact?
We're being upfront with that to every state that we're talking to.
It's uncharted waters.
Yeah.
It's never been tested. We assume that it will be tested, which is why we would preempt that testing and go and seek congressional
Exactly.
approval. We don't think that the compact, the National Popular Vote Compact, as written, triggers, we personally don't believe that it triggers congressional consent. We don't think that it triggers either one of the mechanisms that Jim's outlined there. And by not doing that, it just becomes a state law, which falls into the 10th Amendment, which allows the states to enter into the
determine how
compacts,
they establish.
whereby once the states enter into the compacts, provided that it does not encroach on federal supremacy or have an undoing of political power amongst the states, that Congress would strike it down, it by acclamation becomes federal law. Federal law will adopt the state law. It is juxtaposed where you have like the Columbia River Gorge Commission, where the federal government created the compact and required the states to enter into it. Thereby, once that happens, it's in that the senator had asked earlier, when the Congress mandates that a compact be imposed, like that example, that's when an administrative bureaucracy is created to administer that compact, okay? It's only when Congress requires the compact to be established that the administrative bureaucracy is created to facilitate that compact. And that's where the whole argument is who is that administrative bureaucracy accountable to? State or federal? It's a whole nother, it's never been tested, but that's a whole nother, that's an entire law school class on compacts that's only offered in 2 colleges in America. So I was fortunate to take that class. It's mind-numbing, but yes.
Does Congress just generally approve compacts? Do they just pretty much do that, and is that just unanimous consent kind of thing? Or?
So if the compact does not trigger congressional consent, where congressional consent is sought, and the states enter into the compact, and the objection is not raised by acclamation, it becomes federal law. Federal law adopts to the state compact in this situation. Does that make sense?
One other observation, though, all the precedent and the examples that Jim have given here are related to minerals, energy, basic functions, infrastructure. When you venture into elections and the political aspects of that, that's pretty well uncharted in terms of compacts. Is that
Well,
correct?
yes and no. We believe that the National Popular Vote Compact is utilizing 2 components of the U.S. Constitution. Obviously, we'll probably get into that later. But it's the Compact Clause, which you're going over right now, and the states' rights that are explicit in Article 2, Section 2 of the Constitution that allows the states to determine how their electors are chosen. So it's combining the 2 mechanisms that are allowed for within the Constitution, compacts.
But has there been a precedent for that type of, this particular type of, a non-infrastructure, non-mineral,
You can go back to 1892. It was McPherson versus Baker. There's a seminal case of the United States Supreme Court, and it reemphasized the fact that the appointment of electors is a plenary state power.
right?
So it doesn't infringe on federal law at all. So what we're talking about here
But
is
there's no compact.
there's no compact.
But what you're asking is there anything related to elections, right? Is it my understanding
Or
correctly?
non-infrastructure.
Non-infrastructure compact.
The Lotto, the Powerball is one, yeah.
Good example, good example. I was stuck there for a second.
Sometimes you gotta gamble. It's going in there.
You took that class.
I was bet on Greg.
Well, education and, Indian gaming compacts are really not infrastructural, they're quite political.
But the interstate, the tribal compacts, a lot of them now come under IGRA, which was set up in the late 80s. So a lot of those compacts were developed under that. Another one, kind of like the Columbia River Compact. Here we're dealing with a strict plenary state power.
Right.
Nothing in the compact we have touches anything provided for under the federal constitution or under federal law.